This committee alone represents over 3,986 educators with complaints against him, with one district reporting as many as 898 complaints.
We let our kids spend the majority of their time in schools. Why would we strip their protection when they're away from their parents the most?
Now, if we look at the national average of 20 victims on average before an abuser is caught, that means here in this room today, we're looking at over 79,720 potential victims. I need you to let that sink in.
Improper student-teacher relationship is not the right way to put it. This is child abuse. This is sexual abuse, and we should call it what it is.
It is so hard to see what's happened to my profession. I just want to say that. It has changed, I think, over the last 10, 20 years, and we have to correct it. I think we absolutely have to correct it.
Correct. Thank you, Chairman Leach, for bringing this bill. Thank you, Representative Little. You are a hero for Texas children. I'm sorry, I shouldn't be so emotional, but
It's okay.
This is consequential. Chairman Morath spoke before the the State Board of Education meeting, and he gave new updated information about abuse reports for the fiscal year 2024. 886 reports of sexual misconduct in 2024 in our schools. Those are only the ones that are reported. 1,738 reports of physical abuse. You're going to hear from the victims today, and I want to let what they have to say sink in. It matters. Our organization has been conducting research over 2.5 years. We've worked with various grassroots groups around this country. We're all a bunch of volunteer parents. We don't get paid for this. We're doing this on our own time. We help parents when their children are harmed in a Texas public school. We don't get a lot of sleep. You can't imagine how busy we are. Most parents reach out on social media after they have been abused, their child's been abused by a school employee, and then they get railroaded and gaslit, and then their child is just, completely broken. They have nothing to show. There's no place for them to get remedy. When they try and file a grievance, the school district denies it 3 times. They're not looking at the evidence. They're not looking. There's no due process in a Texas public school. There isn't. Constitutional process, due process doesn't matter there. And then when they take that appeal to the commissioner, the TEA's own data betrays itself. 90% of parents who took an appeal to the commissioner in 2024 were denied for lack of jurisdiction. There's no due process, and then they can't take this issue to the courts because the schools are shielded from immunity. You have the power to give some responsibility, put it where it belongs, and give these parents and these victims a way out. They need it. Please see this report. The back has our complete solution. All the problems in the system we have gone through. And to answer your question, Representative Schofield, and you can ask more later, but yes, the state is complicit. That's why we call this state-sponsored child abuse. The TEA has known that this has been a growing problem for quite some time, and all the information is in here.
All right,
I'm happy
thank
to take
you.
questions.
Thank you, Ms.
Thank you.
Plakowski.
These are not abstract numbers, these are real Texas children. And too often, these predators quietly resign, only to be rehired elsewhere. 6,888 involved sexual or violent offenses, ranging from sexual harassment, grooming, to abuse and assault. These are not isolated incidents, they are systemic failures.
We know that y'all can put more laws on the books, but we know that if there is no accountability, they will not follow them.
Right now, our kids are at risk in the system that hides misconduct while they continually put out press releases and statements that the safety and well-being of the children are their top priority.
Horrible as all of the testimony has made this problem appear to everyone on the committee, it's actually much, much worse because, in fact, throughout the state of Texas, anyone who is aggrieved in any way connected with a public school district never gets to go to court even for injunctive relief unless they first ring the bell and exhaust their administrative remedies before the school district. And oftentimes, the school district has time limits. There are many school districts with time limits as short as 10 days, but that acts as essentially another impenetrable barrier that parents and families of sexually molested children have to deal with. They have to file a complaint with the school district that employs their abuser. They have to do it within 10 days. Oftentimes, the parents don't know about it until the 11th day or later. And then
Schools are shielding from accountability. Texas law currently grants government immunity to district and staff, even when they fail to report or act on abuse. This is not justice. This is abandonment.
Even with the evidence, parents cannot win. ISDs will self-investigate, reject proof. They will delay open records by using the Attorney General.
And 10 days just isn't enough time for a statute of limitations on something as serious as sexual abuse of a child that the school district is responsible for putting alongside the abuser.
Immunity blocks us in court. Attorneys will not take our cases, as you guys have heard today.
HB 4623 changes that. It removes immunity when the staff or districts neglect their duty to protect our students, giving families the right to seek civil justice. This is not unprecedented. Other states, as were mentioned earlier, including California, Pennsylvania, North Carolina, Colorado, Utah, Maryland, have already taken steps to waive governmental immunity.
If you want to motivate our school districts, give them a reason to care about what's happening, because when you look at the numbers and you look at the damage that is being caused to our children, it is clear that there is not much motivation.
We know that civil liability will ensure reporting, it will ensure background checks, it will ensure that school districts are doing their due diligence to make sure that they call a previous employer. Real children are harmed, and we know that outcomes for children are improved when they get the right help. And liability will allow children to get the right help because the right help costs money. And many parents might be able to afford the kind of counseling that's required to help a child through this, but many cannot. Many cannot. What happens to those children?
Ask the commissioner what he has done for the last 10 years that he's been the commissioner. Ask what's fueling this epidemic. Treat it as institutional betrayal. Treat it as corruption. Treat it as lack of accountability, because it is.
The system creates and breeds a culture of secrecy because it's designed to protect itself. And so, I have one example in a very small rural school district where a teacher reported what she suspected to be abuse of a child, and she was the one that was punished for reporting it. It's not encouraged to report this kind of abuse. I'm hearing anger and righteous indignation from this committee, and that's great, but it's not enough. You have the power to fix this, to do something. Parents and victims are watching you to see not what you say, but rather what you do. Basically, to Representative Little for refusing to protect those who harm children. Choosing accountability over immunity is the kind of leadership that we need from all of you. And so I am asking you to allow him to show you the way. I urge you all to follow his lead unanimously and pass HB 4623 for our children.
The prevalence of this is widespread and it's deep. There are thousands of instances, members, just to give you an idea, thousands every single year in public schools across the state where intentional torts are committed upon our public school students by public school employees. And in many of those cases, just to restate the problem that we're addressing here, that Representative Little's bill is attempting to address, is, correct me if I'm wrong, that I'm going to state it as simply as I can, that an intentional tort by a school employee can be committed upon a student, and the school district, even if they had knowledge of that, if, for instance, it happened at one campus and they transferred that employee to another campus and it happened there, the public school cannot in any situation be held liable.
That's my understanding.
No liability whatsoever, none.